Good day, Crime Talk aficionados. It's Sunday, but we have the weekly recap from all the top stories from the week of May 5th, all conveniently located in one location. Hope you enjoy the show. Remember, the Constitution matters.
All right, lawyer.
Yes, that's right. The secret hearing in the Bryan Kohberger matter. That hearing was held today. It was set for 11:30 today there in Idaho. Obviously, it's in regards to the case of Bryan Kohberger. And it's just days after the University of Idaho murder suspect lost basically every motion that he filed to avoid the death penalty. Now, here we are just 3 months before Kohberger's trial is set to begin. And the Judge Stephen Hippler, has scheduled a closed-door remote hearing today. Now, the details of the hearing are closely guarded secret, with both the media and the public blocked from attending. And as what we can tell so far, no leaks about what was discussed. Now, Judge Hippler has gone to great effort to make details about this trial open to the public. So it is a little surprising that he had this secret hearing. Now, since the trial has been moved to Boise from Moscow, Idaho, there in Latah County, where the murders took place, the judge has allowed cameras inside the courtroom, and he has live streamed all of the proceedings. And the judge also ordered both prosecution and the defense to stop filing records under seal. This one, the reason for filing it, is under seal, and so is the hearing. Anyway, some court documents have revealed many before never known details about the events of the night that Bryan Kohberger is alleged to have committed a quadruple homicide. And it's obviously the hearing, it could be under seal because it involves information about the victims, witness testimony that the court doesn't want to be made public as of yet, evidence that may or may not have been admitted at trial, jury issues, or Kohberger's own mental health or potential competency issues. Maybe there's a potential plea deal on the table. Who knows? It could be anything. So like I said, it could be something procedural, or it could be something very important, or it could be really nothing at all. Generally, hearings and documents are not sealed in criminal court cases, except in Idaho, as we've discussed several times on this channel. And it is frustrating that this requires, at least the judge thought it required, to be held in secrecy. Hopefully, the judge will issue orders on it, and we'll get to find out what it is about. Normally, there is a presumption that these things need to be held in public. Like I said, Judge Hippler has pushed for these unsealing since taking over the case, and so it was a little surprising that he did this. Something being done in private and sealed should be the exception rather than the rule. The judge has stated himself in orders, and he's even stated that he wants great transparency and access, and he would lift the very broad gag order in the case. Now, due to this case being not typical when it comes to public access, it is difficult to determine how critical the sealing may have been. And had it been something like the Vallow case or the Daybell case, where everything was done in secrecy, that was very troubling to me. Very disturbing. How do we know what took place? How do we know if the prosecution, the judge, and the defense were being treated fairly? We don't. I think it's a travesty of justice when things like this are sealed. Anyway, like I said, this Judge Hippler issued this mystery notice of the sealing hearing on April 30th, just 1 day after the judge handed down the latest court orders. And all those orders was kind of a blow for the defense in the Cobberger case. And the judge dismissed Kohberger's efforts to stop a jury from sending him to death row. And despite the timing of this hearing coming after the orders, we can't really say that maybe, like I said, is Cobberger going to change his mind for a plea deal? Is there going to be something that's been resolved? I don't necessarily think that will be the case, but you never know. We saw that in the Chris Watts case. I remember when they set it for a hearing, I said, well, they're either going to reschedule this hearing for the preliminary hearing, or they've reached a deal. And sure enough, they did. And those are sometimes things that take place. And if there is going to be a plea deal, I'm assuming that the parties would discuss with the judge whether they thought this is appropriate, whether the judge would allow it. But that's going to require lots of moving parts on the other side. But remember, this is a death penalty case. Death penalty's attorneys think they win if they take death off the table. Even better yet, if they can get life. But normally the prosecutor wants acceptance of responsibility. And then we hear from the defendant's own evaluators, psychologists and what have you, that evaluate him, saying that he thinks he's going to be acquitted. So usually they want complete acceptance of responsibility on the record before some sort of plea is accepted in a death penalty case. Anyway, so could there be a deal? Could there be not? Yeah, it's possible. I just don't necessarily think that's going to happen from what we've heard thus far. But, what can you do? This is obviously a very serious case, one of the most gruesome murders, not only in the United States, but certainly Idaho. You got 4 college students brutally stabbed to death for no apparent reason. A lot of prosecutors wouldn't necessarily cut a life without the possibility of parole deal unless they thought that there was some weakness in their case. And there'd probably be a huge uproar against making any kind of a deal as well. But like I said, we won't know unless the court issues an order stating what the secret hearing was about. Now, like we brought you last week and the week before last, we brought you all the court orders. But for those who have joined us for the first time, the court dismissed Cobberger's efforts to strike the death penalty over what it claimed was the prosecution's lengthy delays in handing over voluminous and unorganized discovery in the case. The defense claimed that it was unable to prepare properly for trial, arguing that this was a violation of Mr. Cobberger's rights and asking the judge to strike the death penalty. Judge Hippler tossed those requests and blasted Cobberger's attorneys, basically saying that their complaints against the prosecution ring hollow. The judge said specifically, defendant complains of being unable to meaningfully review the discovery. That rings hollow. Defendant has been receiving discovery in the same manner for the last 2 years. No complaints. Dismissing the idea that there had been any misconduct by the prosecutors, the judge pointed out that Cobberger had asked for everything, and everything is what he received. And he said that the defendant cannot demand everything under the sun and then complain about the weight of all the planets. He scolded the defense. Anyway, the ruling came 1 week after the judge denied a separate request to strike the death penalty due to his recent autism diagnosis. The defense had come up with an expert who just recently diagnosed Mr. Cobberger with autism spectrum disorder level 1. And the significance of that is they're trying to look for some sort of disability, because if you're disabled, mentally impaired, then the United States Supreme Court says you cannot be subject to the death penalty. Anyway, the defense argued that the demeanor of Mr. Cobberger, because of his diagnosis, would place him at greater risk for being sentenced to death, and arguing that every move Mr. Cobberger makes is scrutinized, and claiming that he has been presented in the media as evil and soulless. The state, however, argued that the precedent previously set to strike the death penalty are for intellectual disabilities, and autism is not in that spectrum of intellectual disabilities. The judge ruled that Mr. Cobberger's diagnosis can be used as a mitigating factor if sentencing is at issue, but does not mean that the death penalty should be removed from the case. Now, Mr. Cobberger could face the firing squad if convicted and sentenced to death due to some recent changes in the Idaho state law. And also in another order, the judge also ruled that the jurors will be able to see Cobberger's Amazon shopping history. Prosecutors say his shopping history reveals that he bought the K-bar knife, sheath, and sharpener from Amazon back in March of 2022, and a K-bar leather sheath was left behind by the killer next to Madison Mogen's lifeless body. And then DNA found on the sheath back as a match to Mr. Cobberger, and the murder weapon itself has never been found. Now, the DNA, the defense all but conceded, was in fact Mr. Cobberger's. They made no claim that it wasn't his, but they provided no explanation how his DNA just happened to be on a K-bar, which he allegedly purchased from Amazon, which was his, and it just happened to be underneath the deceased body of Madison Mogen. We'll have to wait for trial for that, I guess. Anyway, Mr. Cobberger was arrested 6 weeks from the date of the slayings at his parents' home in Pennsylvania. As well as the DNA evidence and the eyewitness testimony, prosecutors say Mr. Cobberger's white Hyundai Elantra also matches the car seen leaving the crime scene at the time of the murders. And there's also cell phone records that indicate that he may have been kind of hanging around the King Road home at least a dozen times leading up to the murders. So hopefully we'll find out some information soon about the secret hearing. Could it be a plea deal? Could it be a scheduling issue? Could it be an issue related to Mr. Cobberger? Who knows? Maybe he wants to fire his attorneys Maybe he wants to, raise competency. Who knows? But that's the problem when you do stuff in secret. Everybody starts to speculate as to what's taking place. Let us just have the facts. We're big boys and girls. We can handle it. Next, let's talk about the sheriff who shot the judge. New surveillance footage captured the moments that led a Kentucky sheriff to shoot his longtime friend and local judge, Ken Mullins, in his chambers. Now, the alleged murder unfolded September 19th, 2024, when the Letcher County Sheriff, Sean Mickey Steins, was seen in a footage entering Mullins' office as he sat with several others in the judge's chambers. Now, Steins and Mullen had been out for lunch together with several other people in Mullins' office shortly before the shooting, and the sheriff appears to order the others out of the room at the start of the footage. Now, the video shows Stein confronting Mullins as soon as he enters the room, sitting across from him and the desk and bringing something up on his phone. At one point, Mullins hands his phone across the desk to Steins before the sheriff takes the phone and attempts to make a call that doesn't appear to have been answered. Steins then briefly looked through the phone before tossing it back on the desk, with Mullins still appearing to try and calmly talk the sheriff down from a rage. The footage then shows Steins stand up and lift up his shirt to reveal his gun holster on his hip, which caused the judge to then take notice and lift his hands up. Prosecutors have obviously charged Steins with first-degree murder. However, his attorneys indicated they are preparing to mount an insanity defense in the upcoming trial. The footage offers the clearest look yet at the shooting last year that obviously shocked the small town of Whitesburg, Kentucky, where the two men played important roles in their community. Now, they were known as longtime friends and often ate lunch together, including on the day that Mullins was killed. Now, their familiarity was evident in the footage from inside Mullins' chambers as the judge sat smoking a cigarette with his legs crossed as Steins grilled him. Although the footage was released without sound, you can tell from the video that the sheriff was ready to go the minute he walked in. By contrast, Mullins is very nonchalant, very carefree. He's smoking a cigarette and didn't appear to understand what the imminent danger he was in. At one point, it looks like Mullins is shrugging everything off, and it created a little more angst towards the judge because he wasn't taking it seriously, whatever was being spoken about, and he kind of playing off as it wasn't kind of a big deal from the video. Now, the judge is kind of going, "What are you doing? Put the gun down," using his hand gestures, kind of flinging him out like, "What are you doing?" In a sudden move, the judge then puts his hands up by his head in an apparent reaction to something the sheriff said. The footage ends as Stein allegedly shot Mullins as he sat in his desk chair. Now, the motive behind the shooting remains unclear. However, Stein's attorney indicated in court filings in March that they intend to launch an insanity defense. Defense attorney Jeremy Bartley filed a motion saying his client's state of mind at the time of the shooting would be key to the upcoming trial. He said the case will hinge on testimony that Steins gave at a deposition days before the September 2024 shooting. At the deposition, the sheriff had to answer questions about one of the deputies allegedly sexually assaulting jail inmates. An accuser in that case claimed that she was forced by a deputy sheriff to have sex in Mullins' chambers for 6 months in exchange for staying out of jail. Now, Bartley said Steins feared that backlash from his deposition testimony caused him to fear that his or her family's lives were in danger. The attorney said Steins' mental health was affected by that perceived threat. Ultimately, he was in fear for the safety of his wife and his daughter, and I think you will see there is a result of that, the defense attorney noted. Bartley added that although Steins tried to call his daughter from Mullins' phone, their phone exchange had nothing to do with any relationship between the judge and the sheriff's daughter. He added that Steins received a call from his aunt during his interaction with Judge Mullins in his chambers, which was one of the times that he brought out the phone from his pocket. As The attorney also denied rumors of any kind of relationship between Mullins and Stein's daughter. The attorney noted, and he said his client was experiencing increased paranoia over the safety of his family at the time, particularly due to the deposition he had just given. Specifically, in the approximate 2-week period prior to the incident in the judge's chambers, pretty much all the witnesses the investigators talked to support what those close to Mickey had said as well, according to his attorney. And that's simply this. Mickey had become extremely paranoid. He'd become sleepless, basically wasn't sleeping. He slept little, if at all. He had become withdrawn. The attorney said, as you know, it was of such a concern that his coworkers had actually urged him to go to the doctor, and ultimately the day prior to the shooting. Little breaking news there, I guess. Nothing as it relates to a relationship with the judge and the sheriff's daughter, which is obviously a good thing. Going to be tough to do a mental health defense unless you can say that he is actually suffering from some sort of mental disease or defect. Good luck with that, Sheriff Steins, or former Sheriff Steins to be more accurate. You can raise the defense, but I don't think it's going to prevail on this one. Next, Luigi Mangione gets a big birthday gift. That's right. It's a killer birthday gift, you could say. The legal defense fund for Luigi Mangione reached more than $1 million in donations Tuesday, with droves of starry-eyed supporters pitching in to help the alleged United Healthcare CEO assassin on his 27th birthday. That's right. Happy 27th birthday to the man, the myth, the legend. You are so loved. May you stay healthy and strong and keep the fighting spirit inside you. One anonymous fan wrote while donating $27 for Mangione's 27th birthday. The person also said, "This is my 7th donation, and I will keep donating as long as I need to. You are fighting for your life, but you are there. There is an army behind you. We are not going anywhere." The crowdfunding campaign on the Give, Send, Go fundraising website raked in $1,042,000 as of Tuesday afternoon, with 28,000 contributions, averaging $27. There you go. Anyway, a spokesperson said that people have forked over $27 as a way to celebrate Mr. Mangione's birthday, which is today, May 6th, which was actually yesterday. Anyway, the money will go for Mangione's defense for his 3 pending legal cases. And obviously, Mangione is accused of killing the United Healthcare CEO, Brian Thompson, outside of a Hilton hotel in Midtown Manhattan on December 4th. The cold-blooded video shows the murder, but apparently murder is not enough to not become a social media presence. That's right. Legions of fangirls have flocked to Mangione's court appearances, and protesters denouncing the healthcare industry. Now, Mr. Mangione has pled not guilty to murder, stalking, and firearm offenses at his Manhattan federal death penalty case last month. And a spokesperson for the legal defense fund for Mr. Mangione says the milestone was reached because of the continued response. The milestone has been reached because of the continued resonance of Mr. Mangione's story. They said in a statement, he has become a contemporary folk hero, understood by millions to be brave, righteous American, concerned with the lived experience of the common man. Wow. The new court orders in the Bryan Kohberger matter. Now, I hate to say that I got it right again. Not trying to say I'm always right, because I make mistakes. But what did I brought you the show yesterday? The reason why they had this hearing was the order as it relates to the examination of Bryan Kohberger, just like I thought it would. So why would you go? Why would you go to any other source out there for analysis on this stuff? When have we got this wrong? We don't. That's what 30 years and still trying cases brings you. Knowledge, experience, ladies and gentlemen. That's why you're here. All right, let's go ahead and get rolling on it. So in these new court orders, Judge Hippler ruled that Kohberger's immediate family members can support him in the courtroom every day of his high-profile trial, even before they are called to testify against the relatives. Now, the defense had argued that under the Sixth Amendment right to a public trial, Mr. Kohberger has a right to have his family present in the courtroom. But typically, witnesses cannot attend a criminal trial until after they've taken the stand to prevent their testimony being being shaped by what they hear in court. It's called a sequestration order, ladies and gentlemen. Anyway, and prosecutors had previously revealed that they planned to call some of Bryan Kohberger's family members, specifically his father, Michael, his mother, Marianne, and the two older sisters, Amanda and Melissa, as witnesses for the state of Idaho. Now, which family members will testify for the prosecution is still a mystery, but those details obviously are closely guarded, but have been apparently submitted to the court for review and have not been made public. So what I intend to do, ladies and gentlemen, is give you a recap of these orders and explain them. And then at basically the end of the show after the dumb criminal, for all the CrimeTalk aficionados that just geek out on this stuff, we'll go through the entire order in its entirety. All right. So let's do that. All right. So the judge, probably made the right call in this particular case. I mean, the parents' testimony, interviews, things like that, they're locked into stone. If they deviate from that in any way, they'll be impeached. It's probably not that big a deal. It's a death penalty case. Let his family sit in the courtroom there until they're called. I get that. And frankly, you never know. Sometimes the family hearing it for the first time, sometimes they come around and say, oh my gosh, I didn't realize the facts were so bad. I once had a big drug client who was in federal court, and my client's son showed up and heard the testimony. He kept thinking that she was, my client was, she was innocent. Oh my God, it's terrible. And which is not uncommon. People tell their family different things out of embarrassment or for their own personal reasons. Anyway, and as the trial went on, the kid kind of looked at me and he goes, well, geez, I didn't know all this. I didn't realize my mom was like El Chapa. So sometimes it's good for the family to hear the evidence because sometimes they tune that out and it lets them know that the attorney's kind of done everything they can and this is a bad case. All right. Next, though, let's talk about the next court order. The court also addressed the state's motion to conduct a mental health examination of Mr. Cobberger under the Idaho Code, Section 18207, subparagraph 4, subparagraph C, and to extend the penalty phase rebuttal disclosure deadlines. Now, the defendant's disclosures of the expert opinions on mental conditions relating to the autism spectrum disorder, obsessive compulsive disorder, and attention deficit hyperactivity disorder triggered the state's right to examine Mr. Cobberger. The key dispute were the examination's scope, defense counsel's presence, and the extension of the disclosure deadline. Well, the court ruled on the motion yesterday at this video secret conference, and of the key issues on this particular case. So the extension of the rebuttal disclosure deadlines. First, the issue was the state requested a 21-day extension beyond the examination to disclose its expert's opinion, citing the unexpected withdrawal of their initial expert. The defendant argued there was no good cause and that an extension would prejudice the defense due to the case's timing. Now, the legal standard for an extension requires good cause under Rule 45 there in Idaho, implying unforeseen circumstances beyond the party's control, not lack of diligence. The court considers the potential prejudice to the defendant. The court ultimately ruled. The court granted a limited extension to May 27th, 2025, finding good cause due to the unforeseen withdrawal of the state's expert 2 weeks before the April 28th, 2025 deadline. Now, the shorter extension balances the state's mandatory right to examine Mr. Cobberger with the need to avoid prejudicing the defendants given the trial proximity. So the defendant must be available for examination within 7 to 10 days, giving the state's experts about 2 weeks to complete the report. Court noted the state should have moved for an extension earlier by April 3rd, but found the delay excusable due to the expert's withdrawal. Then the next issue was the scope of the examination, this personality testing. The big issue was the state sought to include personality testing to validate the defendant's self-reported symptoms and rule out other diagnosis. The defendant objected, arguing it exceeded the scope of the rebuttal, limited to just the ASD, OCD, ADHD, eating disorders, and the substance abuse issues, and it violated his Fifth Amendment right against self-incrimination. Well, the legal standard under this Idaho Code Section 18207-4C, the state's examination is limited to rebutting the mental conditions raised by the defendant. The Fifth Amendment waiver applies only to those conditions and not the defendant's entire mental state, the court ruled. Therefore, personality testing was not allowed. The court found personality testing was unnecessary to validate self-reported symptoms, as the defendant's expert, Dr. Orr, relied on extensive external data, interviews, records, rather than self-reports, and the defendant showed minimal self-reporting. Now, testing due to rule out other diagnoses risked generating new evidence beyond the Fifth Amendment waiver, potentially creating aggravating evidence or necessitating further testing, which would delay this case. So the court had to balance what needs to be done. So the defense experts cannot testify about the defendant's lack of personality disorders or reference the state's failure to conduct personality testing. The state's experts may note that personality testing could have aided evaluation, but was not conducted by either side. The defendant cannot imply the state's experts could have conducted such testing, and the defense counsel's presence during examination, which is the other big issue that the court had to address. First, the state sought to exclude defense counsel from the examination room, citing standards of psychological practices and the experts' concern that counsel's presence would affect the validity of the testing and interview. The defendants argued the Sixth Amendment guaranteed counsel's presence, especially in a capital case, as the examination is a critical stage of the proceeding. The court looked at the legal standard and says the Sixth Amendment guarantees counsel assistance at critical stages of the proceedings, but does not necessarily require counsel's presence during mental health examinations. And the court cited to authority on that. Most courts hold that such examinations are not critical stages, or that they do not require the right to assistance of counsel and to have the counsel present. Therefore, the court ruled defense counsel's presence in the examination room was not allowed, but counsel for both sides may observe via a one-way video feed or similar method to ensure that there's no interference. Wow. So, but the court did go on and explain that Idaho case law established no Sixth Amendment right to counsel during being present, only basically there to advise before the examination. So the court rejected the defendant's argument that the capital case warrants a different treatment as the case law that the court was relying upon. And just kind of a way of procedural background on this, because it kind of goes to why the state delayed everything. So back in January of 2025, the defendant disclosed their guilt phase expert opinions and their diagnosis of mental conditions. On March 31st of this year, the defendant disclosed the penalty phase expert opinions by 5 professionals. Then on April 2nd of this year, the state and defense counsel discussed the examination with disputes over the personality testing and counsel's presence. And then on April 11th, the state's initial expert withdrew. A replacement was retained by April 18th. And on April 22nd of this year, the state confirmed the new expert's stance and sought a deadline extension which the defendant opposed. Then on April 25th, the state filed the motion. May 5th, the court held a sealed hearing and ruled from the bench. Obviously, what I just discussed. So the order was granted in part with a limited extension of the rebuttal disclosures. The examination is allowed with both sides' counsel observing via the feed, and denied in part in that the state does not get to do the personality testing that they so desire to do for the penalty phase of the hearing. Like I said, I'll go through that further as it relates to all of the full order at the end of the show for those that want to hang out and listen to that. Next, Lori Vallow. So as you know, she was convicted and she's got yet another trial, but she was convicted of conspiracy of committing her husband, Charles Vallow. And then she filed a motion for a new trial. Well, the prosecution has responded. So Lori Vallow filed a motion for a new trial in Arizona following her April 25th conviction for conspiracy to commit murder of her fourth husband, Charles Vallow. Now, the prosecution and defense presented detailed arguments addressing the motion, which centered on several key issues. Lori Vallow's arguments for a new trial include And remember, she's appearing pro se on this. First, jury misconduct. Vallow claims that the alleged juror number 15 was aware of her prior Idaho convictions for the murders of her children, Tylee Ryan and JJ Vallow, and the conspiracy in the death of Tammy Daybell. She argues that this knowledge, not presented as evidence in the Arizona trial, prejudiced the juror's impartiality. Now, the claim stemmed from the interview with Juror 15 conducted by Hidden True Crime, which Vallow cited as evidence of the juror's exposure to the extraneous information. She says that this compromised the fairness of the trial. She also says that there should have been a preclusion of statements by Tylee Ryan and Alex Cox. Vallow argued that the court improperly excluded statements made to police by her daughter, Tylee Ryan, and her brother, Alex Cox, who shot Charles Vallow. She contended these statements were critical to her defense as they supported her claim that Cox acted in self-defense. Specifically, Vallow asserted that the statements from Cox and Tylee were made during police interviews following the July 19th shooting shaped the initial police response, which treated the incident as self-defense. She argued the excluding these statements prevented her from presenting a complete defense. Well, Ms. Vallow, as you know, as a lawyer and all, those statements were testimonial in nature, and they're not admissible when the individual cannot appear in court and be subject to cross-examination. You probably knew that already, though, Lori, because you're like a lawyer and all. Anyway, there's also an allegation of a discovery violation where Vallow alleged that the prosecution failed to disclose evidence in a timely manner, violating the discovery rules and hindering her ability to prepare an adequate defense. Specifically, the nature of the alleged violation is not detailed but Vallow claimed it impacted her trial preparation and fairness. Now, she also claims prosecutorial misconduct. She accused the prosecution of engaging in misconduct though the exact nature of the alleged misconduct was not fully specified in her motions. The claim is likely related, though, to her broader assertion that the prosecution's actions, possibly including their handling of evidence or statements during the trial, were improper and prejudiced the outcome of the trial. She also said the court lacks impartiality. That's right. Vallow says that the trial judge who presided over her case lacked impartiality, which affected the fairness of the proceedings. Once again, she did not provide specifics on the bias in the motion, but the claim suggests that the judicial rulings conducted during the trial favored the prosecution. Welcome to criminal defense, Lori Vallow. Welcome to criminal defense. Now, the prosecution filed a response to all of these allegations, and needless to say, they say first, there is no juror misconduct. The prosecution refuted the claim of juror misconduct by citing an interview with Juror 15 conducted by Hidden True Crime, which clarified that the juror only learned of Vallow Daybell's Idaho convictions after the Arizona trial verdict was delivered and the jury was released. They emphasized that the juror was required to sign daily declarations confirming that they had not been exposed to improper or prejudicial information as per court instructions. The prosecution argued that no evidence supported Vallow's claim that juror 15 had knowledge of that information during the juror deliberations. The prosecution also maintained that the court's decision to exclude statements by Tylee Ryan and Alex Cox was legally sound and did not prejudice Vallow's defense in any way whatsoever. And they basically argued that since Vallow could not benefit from statements by witnesses she was convicted of killing, the prosecution notes that Cox's interview at the scene of the shooting was admitted, but Tylee's statements were excluded as irrelevant or prejudicial, a ruling they defended as appropriate. And once again, the prosecution says, deny any discovery violations, asserting that they have complied with all obligations to disclose evidence to Ms. Vallow in a timely manner. Needless to say, the prosecution also says there was no prosecutorial misconduct. They rejected that accusation, arguing that their conduct throughout the trial was professional and adhered to the legal and ethical standards that they are bound to abide by. As it relates to judicial impartiality, the prosecution defended the court's impartiality, asserting that the judge conducted the trial fairly and made rulings based upon legal merits. Of course, they think so because they won, but I get it. The judge, I thought, did a very good job throughout the trial in that particular case. Anyway, those are the allegations. Those are responses. The judge will have to rule on the motions, but you can expect the motion for a new trial will be denied. All right. It's that simple. No judge is going to admit that they made a mistake at the trial level that resulted in an unfair trial and to do a do-over. Simply not going to happen. That's what appellate courts are for, right?